Hello, hi everyone. I'm back another video on right to freedom of speech and expression. But before jumping into the video, I would request all of you to like, share, and subscribe to my channel. Also, I would like to say that please stay safe, stay healthy, stay at your homes. Don't go out unless and until it's really urgent for you to go out, and we'll be taking up whole topic of constitutional law here through online mode, through videos, and you are going to get all the insights of the subject of Constitution of India. Though I cannot say that I am an expert of constitutional law yet, because every time you read any law, you come up with new interpretations of it, new aspect of it, new side of it. So but still I try, because being an assistant professor, I've been teaching constitutional law to various students of BA, BCom and BBA. Hence I am trying to come up with every single thing to thick, and I'm trying to clear all the concepts over here. So let's just jump into the concept. आर्टिकल 19 बात करता है फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन की. फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन का मतलब हुआ कि इस सारे सिटीजन्स को, इस कंट्री के सारे सिटीजन्स को ये राइट है कि वो उनके पास फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन होगा. वो एसोसिएशन बना सकते हैं, वो पीसफुली असेंबल हो सकते हैं विदाउट आर्म्स, वो यूनियंस बना सकते हैं, वो कहीं पर भी पूरी टेरिटरी ऑफ इंडिया में फ्रीली मूव कर सकते हैं, वो कहीं भी रिसाइड कर सकते हैं और कहीं भी सेटल हो सकते हैं, कोई भी रिलीजन को प्रोफेस कर सकते हैं, प्रैक्टिस कर सकते हैं, कोई भी ऑक्यूपेशन, बिजनेस या ट्रेड को वो कैरी आउट कर सकते हैं. बट दीज राइट्स are subjected to certain reasonable restrictions. And what are those reasonable restrictions? We need to understand. When we say that these rights are not absolute rights, these rights are dependent on the certain circumstances and some certain restrictions which are there provided by the Constitution of India under various clauses, clause 2, clause 3, clause 4, clause 5. And what does these clauses talk about? As a whole, when we say these clauses talk about the restrictions which relate to कि अगर आप कोई ऐसी अपने फ्रीडम, अपने इस राइट को इस तरीके से यूज़ कर रहे हो जो कि कंट्री के किसी लॉ को जो है हैम्पर करती है, उसकी ऑपरेशन को रोकती है या प्रिवेंट करती है, किसी का इंटरेस्ट वायलेट करती है, सॉवरेनिटी और इंटीग्रिटी के ऊपर बात आती है, या पब्लिक ऑर्डर और डिसेंसी को वायलेट करती है, मोरालिटी को वायलेट करती है, या कुछ ऐसा करती है जो कि कंटेम्प्ट ऑफ कोर्ट है, या कुछ ऐसा करती है जो कि डिफेमेशन है, मे बी इंसाइटमेंट है टू एन ऑफेंस, जैसे कि आप सेडिशन कर दो, वार करवा दो, गवर्नमेंट के अगेंस्ट इतना कुछ बोल दो जैसे कि वार हो जाए, सिचुएशन ऐसी आ जाए कि ऑपरेशन हो जाए. सो all those rights and when certain things of this sort is committed, then the right to freedom of speech and expression gets curbed out. So in the case of State of Madras versus Giro 1952 Supreme Court, it was said that no general or universal test of reasonableness can be laid down, and the meaning of the meaning of this particular, the interpretation of this particular article would be varying from situation to situation and circumstances, and according to which these 6 rights is being restricted and impunged in the law. These are the restrictions: clause 2, clause 3, clause 4, clause 5, in which the particular reasonable restrictions have been laid down, and these restrictions do vary. Again, in the Hanif Quareshi versus State of Bihar case, AIR 1958 Supreme Court, it was held that the reasonableness should be tested objectively and not subjectively, and it should be tested from the point of view of the general public, and not specifically related to particular caste or particular group of sections of people. Then in the Maneka Gandhi versus Union of India, AIR 1976 Supreme Court, the reasonableness of the restrictions and not the, it was held by the court that the reasonableness of the restrictions and not the law has to be tested. However, under the expanding concept of reasonableness, because the concept has always been changing with the changing circumstances, and the law is getting more enhanced as and when the requirement is being made. So then in those cases, the courts have held that the reasonableness of law should be tested, whether the law is reasonable or not. Then in the case of Bijoe Emmanuel versus State of Kerala, it is a 1986 Supreme Court judgment. It is a national anthem judgment case, whereby the freedom of speech and expression also includes the freedom of silence. In this case, it was held that एक्चुअली क्या हुआ था इस केस में, जो 3 चिल्ड्रन थे जो जिवोहा से बिलोंग करते थे, जिवोहा विटनेस थे, वो एक्सपेल कर दिए गए थे फ्रॉम द स्कूल फ्रॉम रिफ्यूजिंग टू सिंग द सॉन्ग द नेशनल एंथम, and it was obligatory for the students to do so. However, the children stood up respectfully when the national anthem was being sung, but they refused to sing the song as it was against their religious faith. And then the Supreme Court held that the right under Article 19(1)(a) could be curtailed on the grounds mentioned in Article 19(2) only by the law and not the executive. There are no executive instructions regarding these particular containment of the rights, and only the particular law which states the restrictions could curtail that right. Then the second thing which the court held was that the Prevention of Insults to National Anthem, National Honor Act 1971 was not violated as the students stood up and they showed the respect by standing up while the national anthem was being sung. Then the third point which the court held was that the fundamental rights under Article 19(1)(a) also includes the freedom of speech, freedom of silence. Freedom of speech would also include freedom to silence. Hence, this particular right cannot be curtailed. Now, moving on further, when we say, so we say what is the territorial extension of the particular Article 19, particular article. What is the territorial applicability of Article 19? When we talk about the territorial applicability, there is no such geographical limit to which this particular law will be made applicable, and it is applicable irrespective to all in all the full territory of India, irrespective of in which territory you are living. In the case of Romesh Thappar versus State of Madras 1950 Supreme Court, the Supreme Court held that the freedom of speech lay the foundation of all democratic organizations. Unless and until we have a freedom of speech and expression, we cannot lay down the democratic organizations, because it is very important for the people to have their opinion, to put up their opinion, and this particular right has been given to all the citizens to put up their opinions, but subject to certain restrictions. When we talk about Indian Express newspaper versus Union of India 1985 Supreme Court judgment, we say that in this case the Supreme Court observed that the freedom of speech and expression has 4 broad special purposes with which the particular law was made. Those 4 purposes could be like that it helps an individual to attain the self-fulfillment. Because when we say we have the freedom of speech and expression, we say that we have the freedom to express our opinion, we have the freedom to express our intentions, we have the freedom to speak up for ourselves. Then the second thing which the particular law includes in it is that it assists in the discovery of truth. Yes, it's somewhere when opinions are being kept, when the opinions are being seen and the opinions are being interpreted, then there might be a situation where the discovery of truth is possible. Then it strengthens the capacity of an individual in participating in decision making. Obviously, while we are making a decision, a strong decision need to be taken up, we have to have certain opinions, certain guidelines, certain discussions, and those discussions, though freedom of speech and expression is used in those discussions, and the particular opinion of the people, of the citizens, of the executives are being kept. See, जो हमारे पार्लियामेंट में लॉ बनाते हैं वो वी द पीपल ऑफ इंडिया, वी हैव गिवन द पावर टू देम. They are representing us. They are our representatives. Whatever opinion we have, they have that duty to put up those opinions over there in the parliament and to make the laws accordingly, according to the need of the society, according to the need of the hour, according to the need of the circumstances. So the fourth point, which says that it provides a mechanism by which it would be possible to establish a reasonable balance between the stability and the social change. So this was all about freedom of speech and expression. With this, I would like to end this session. Bye bye. Take care. Stay safe. Stay at home.